Good morning, everyone. It's a beautiful Monday here in Centerville. We had a wonderful weekend. We're gonna make a record in a case, which is a little uncertain. Keith, why don't you come up and have a seat with the defense there?
Is this, are you representing me now?
Sergeant Hasbrook, why don't you go ahead and have a seat? We're making a record in the matter of People versus Brad Lee Johnson. The file number is 221565. This is a competency hearing, or supposed to be. Mr. Johnson has been charged with 2 counts of as a subsequent offender, assault with intent to commit. Those are obviously serious felony offenses. They allegedly occurred in July of 2022. The defendant was arrested in August. He was oppositional and defiant right from the start. He refused to appear for his arraignment on August 11th. We did have a pre-exam conference set for August 15th, and we attempted to do a prelim. And attorney Timothy George has been appointed to represent the defendant. He is here in the courtroom. Also present with him is the Chief Public Defender, Mr. Keith Stickley, and on behalf of the prosecutor, Deborah Davis. Also present with us is Sergeant Jim Hasbrook from the Sheriff's Department. Mr. Johnson is not present. He is continuing his oppositional defiance. At the time of the preliminary examination, I think the witnesses were here. I think they're children.
Yes.
And the defendant, again, was oppositional. Mr. George had filed a motion to withdraw. I reserved on Mr. George's motion, and I ordered a competency evaluation. And on August 30th, the defendant was referred for a competency evaluation at the Forensic Center. We received the report back last week, date stamped August 19th, from the Center for Forensic Psychiatry. Attempting to schedule this matter, by court rule, we're supposed to schedule the matter within 5 days unless good cause shown. So we tried to set it up last week and it didn't work for a couple of different reasons. Anyway, competency hearing in this matter is scheduled for this morning at 9 a.m. And the parties are all here with the exception of Mr. Johnson. I had indicated to the jail that I wanted to see Mr. Johnson face to face, or at least here in the courtroom, to be able to interact with him and determine his competency. The competency report that we have received from PsyD Andrew Cheff, CHEFF, proposes the opinion that Mr. Johnson is competent to stand trial. So the matter was scheduled for this morning. There is still the issue of the defendant's or Mr. George's motion to withdraw, and we were advised by jail staff that the defendant did not wish to come to court. So I said, let's see if we can do it by Zoom, and we didn't have any more luck with that. So I've asked Sergeant Hasbrook to join us. Sergeant Hasbrook, would you raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes, sir.
All right, would you state your name, please?
Jim Hasbrook, Hasbrouck.
And you're the sergeant in charge today in Corrections Department?
That's correct.
All right. Did you have an opportunity to engage with Mr. Johnson this morning regarding his appearance at his competency hearing?
I did on 4 separate occasions.
All right. Tell us about that.
The first time we called into his cell, we told him come up front for court. He said, I'm not going. And then we said, well, you are one way or the other. And he refused again. And then I hung up with him. Then he got back on the speaker box and he said that he had been advised by his mother and his agent that he is not to go to court. So
Advised by his mother and who?
and he called it an agent, which I can't assume, but I'm going to guess it's his dad.
All right.
So then we called in there again and said, can we do it via Polycom? And he said he is not going to court. It doesn't matter if it's on Polycom or in the courtroom.
He wasn't quite that polite. Did he have some other matters?
I'm sorry, I didn't hear you.
What else did he say?
He reiterated over and over again that he's got a visit with his mother coming up, and she's the one, along with the agent, that has continued to advise him not to do any court proceedings whatsoever.
We were also advised this morning by Ms. Davis that there is an open warrant for the defendant from Jackson County on a charge of first degree. Are you aware of that?
I am not. I will have my booking officer run them and see if that warrant's in there.
I don't want to have a situation where your staff is at risk and or the defendant. Essentially, I don't want to bind him in time and drag him into the Polycom room. It's kind of hard to do a competency hearing when he's agitated and in the restraint chair. But obviously he can't just not come to court indefinitely. Ms. Davis, do you have a position here?
Your Honor, I believe that the court has the ability to go forward with the competency hearing without the defendant present, so long as the defendant was given the opportunity to be here and is knowingly refusing to participate. It appears that from what Sergeant Hasbrook has said, he is aware that there's court. He knows that he has the opportunity to participate and he is refusing. And this is something he's continued to do through each step of this process. So we would ask that the court exercise that ability and that we go forward with the hearing in absentia.
Mr. George is in a tenuous situation. The defendant has been particularly uncooperative with him. In the competency evaluation, he mentions the fact that he was going to be trying to get other counsel. He did cooperate essentially with the forensic evaluation. And Mr. George, what's your position?
Your Honor, as the court's well aware, I have filed a motion to withdraw in this case. I've laid out the reasons in that motion based on my contact with Mr. Johnson at the time leading up to the the probable cause conference and the scheduled preliminary examination. He made it clear to me that without going into too many details, that he did not want me to represent him. I think based on that communication as well as my experience, that's why I filed the motion. Obviously, if we were to go forward today, I don't feel comfortable doing anything on his behalf with that motion outstanding. And obviously with Mr. Johnson's request to have other counsel. So I understand the court's position, but I don't feel that I can ethically represent him with the matter as it currently is.
Which is why we've also asked Chief Public Defender, Mr. Stickley, to join us. It's a chicken or the egg sort of thing. Is he competent to fire his lawyer? but we need his lawyer to agree to the copy. He may not agree to anything. He may, as a rule, as you know, will stipulate to the report. If it were up to him, he probably would not stipulate to the report and want this ID doctor here to testify. So we asked Mr. Stickley to be here. And so is he competent enough to allow you to withdraw? And in light of the fact that he doesn't want you as your lawyer, are you able to stipulate to the admissibility of the report? We're chasing our tails. Mr. Stickley, do you have an opinion here?
You're right. I, of course, I greatly respect my colleague here in not wanting to act on behalf when of the client, when the client says that, you know, he doesn't want him as counsel. Or in a unique situation, obviously, where the public defender's office and contract is being utilized. At the same time, it's to use a quote of the court, it's not Burger King, have it your way. We have, I mean, I personally have no qualms whatsoever about Mr. George wanting to, you know, withdraw, but that does put us in the same situation without having, you know, without having the benefit of talking to the client. Does a new counsel really accomplish anything either? And
Well, that's the question is it going to be just as uncooperative with the next attorney that's
Correct.
appointed to represent him? Sergeant Hasbrook, for lack of a better term for it, they're commonly referred to as sovereign citizens. Has he been indicating that sort of thing, that he's not a natural person and all of that sort of thing?
Yeah, that the way he speaks would lead me to believe that he thinks he's a sovereign citizen.
And so his advisor may be someone that's advising him that.
Yes, and I know the last time we went through this, he kept claiming that his dad was his attorney.
Well, I think his father actually was an attorney somewhere, but I also don't think his father was going to come here and represent him in this matter. All right, well, what I'm going to do right now is I'm going to find him in contempt. And I'm going to adjourn this matter for 7 days. I'm going to order 7 days jail for contempt for refusing to come to court. And I guess we can do that indefinitely. But it tolls any time and also tolls the requirement to have this hearing within 5 days of the receipt of the report. And at some point, we may have to drag him here kicking and screaming. But there's not the ability to just be so much of a oppositional defiant that you can't have your case heard. The judge in Waukesha, Wisconsin, who is struggling with that case right now, is struggling with that very thing. The defendant is representing himself in that very serious case where he ran through a crowd of people and several people. She is struggling with the guy. Every day is a fiasco. I don't want to end up with that.
Your Honor, should we subpoena the doctor for the next competency hearing in anticipation of taking testimony?
That would probably be appropriate, which means we're going to need to block out more than the 10 or 15 minutes we usually block out for these.
And is it acceptable to have that doctor appear via Zoom?
Yes, it is.
Thank you.
I have that discretion.
In one brief other question, Your Honor. If we understand he's being held in contempt, if he decides to comply, prior to that scheduling or whatever, would he be released from contempt? And
Yes,
okay,
this is a contempt that he owns the keys to the cell. Also, we perhaps need to explore what the situation is with to further complicate things, Judge Patterson's gonna be gone a lot in November. 7 days may not work. For some reason, my calendar's completely open on November 10th. I'm gonna continue this to November 10th at 9 o'clock. Today is the 24th. I'm gonna order 30 days for contempt. And that will get us into that window. And as Mr. Stickley said, if the defendant determines to comply, I can alter the contempt sentence. But Sergeant Hasbrook, I don't want to put you or your officers in danger. Has he been violent or combative?
Not since the last time we tried to bring him to court.
You had to fight with him back in August?
Yeah, we physically took him out of his cell and handcuffed him and brought him for court security.
Again, I don't want to put people at risk. He can appear by Zoom for that November 10th hearing. But he's gonna appear either in a restraint chair or otherwise. But we can't just go on indefinitely with him refusing to appear. He'd been there as long as Wade Allen, which we're up to almost 3 years of him being in the county jail. All right, thank you for your help. Thank you for your professionalism. We will continue this until November 10th. I find the defendant is in contempt of court for failing to appear. I am reserving again on Mr. George's motion to withdraw. I'm inclined to grant it, but again, I don't know that he'll be any more cooperative with any other counsel. But I understand the position it puts Mr. George in. And Deborah, you can then subpoena the witness for that date. Hopefully that's enough lead time to do that.
Sure, I will have it staffed to that today. Thank you.
All right, Sergeant Hasbrook, thanks for your help. Yeah, you're good to go.
Thank you.
All right, anything else we should put on the record here?
No, Your Honor.
All right. All right, we are live. Let me turn the record on. We're here with Tim George and Deborah Davis. We've got Mr. George and Lori Hines, and Paul Gibson's got one, and John Bush. We're waiting for them to bring in Bradley Johnson. We've had some difficulty with him. All right, we're gonna hope for the best. We got Bradley Johnson here, and he's the guy that was so uncooperative. I'm gonna bring him in, and let's hope we don't end up with a bomb in our laps. Well, apparently he's not there yet. Well, that cell is still dark. That's not a positive sign. Tim, it's not a very good sign. They have not been able to get Mr. Johnson into that room, so we'll see how we're doing.
You're talking about the Polycom room next door here?
Yeah, no, we're gonna try to talk to Bradley Johnson.
Oh, I see.
I'm gonna call the jail and see what they can tell me, what's going on. Mr. Johnson. How's it going with Mr. Johnson? Well, I asked to have him brought down to the Polycom room, and that was about 20 minutes ago. I haven't seen anything yet. This is Judge Middleton. All right, thank you. Bye. All right, I'll call the jail again. This has been a struggle. He wouldn't come in, he came in, I wasn't ready, he left. How are we doing with him? All right, we're all holed up waiting for him. I would respectfully request his presence. All right, thank you. Bye. Tim, why don't you come up and have a seat? So we have 2, 4 pleas to take. And this guy is jamming us up, which he has been for some time now. I would think as charming as Sergeant Heath is, he'd be able to get him to come right down. His birthday's coming up here later this month.
Yeah, I got a big one this year.
Finally turning 21.
60.
What?
Yeah. Just gonna wear it.
There anything else you can do about
Badge
it?
of honor. It means I'm that much closer to retiring.
Lori, I've discovered that 60 is really not that much different than 59 and a half.
There you go. Yeah, so the judge, Sergeant Heath, and I all share the same birthday.
Oh,
It's a big day.
big day. Should have a big party
There you go.
at the jail.
Tim, I apologize. You've struggled with this guy. I'm not even sure where we're gonna be. Oh, here we go. Mr. Johnson, can you hear me?
He can hear you.
All right, Mr. Johnson. This is file number 221565FY. You were charged with in the second degree, 2 counts. And your lawyer, Mr. Tim George, is here at the courthouse with me. Also Prosecutor David Marvin and Assistant Prosecuting Attorney Deborah Davis. This is the time for a pre-exam conference in this matter in advance of a preliminary examination, which would be set for next Tuesday. So far, you've been particularly uncooperative about appearing when you're supposed to be, and I found you in contempt the last time because you failed to appear. We need to move this case forward. Your lawyer, Mr. Johnson, or Mr. George is here. Are you willing to speak to him?
George is not my attorney.
All right. Well, you've expressed that you had somebody that was going to be your lawyer, but so far no one else has filed an appearance on your behalf.
Your Honor, may I interrupt?
Yes.
I'm concerned if we can't see him that he's gonna say he was never here and this didn't happen and I don't want an appeal.
All right.
So just a camera view would be nice.
All right. Well, we'll see where we go. Mr. Johnson, would you have a seat in the chair?
Says no.
Can we turn the camera?
Mr. Johnson, you can't avoid this case by simply saying, I don't want to participate. I'll continue to find you in contempt.
Why is it doing that?
Why did they?
He just walked out. And all right. At some point, I'm going to ask that he be put in a restraint chair and have his skinny ass dragged back in that room.
They're trying to.
Sergeant Hasbrook, he obviously just walked out.
They're trying to get him back now.
All right.
That door has a lock on it.
Yeah. I found him in contempt on October 24th and ordered a 30-day sentence.
Want him back in the restraint chair?
Yes.
Okay.
Mr. George, have you ever had an opportunity to have a meaningful conversation with this defendant?
No, Your Honor. There's been multiple attempts, but never anything meaningful.
Also, the people have witnesses who have been jerked around. This allegedly occurred last summer, July of 2022. The matter is set, the defendant fails to cooperate, it's adjourned. The defendant fails to cooperate. I can find him in contempt every 30 days for the next 2 years. But that doesn't do any good for the complaining witnesses or to otherwise move this case forward. There's also an issue regarding his competence.
Back in the room, I cannot get him in front of the camera without putting him in the restraint.
It's so
So
funny.
give me just a few minutes. He's right there.
All right, Mr. Johnson, have a seat.
The stipulation plays out.
All right. Mr. Johnson, you need to be in the picture, or I'm gonna have them put you in the restraint chair and wheel you in there so you and I can speak. All right. Talk about passive aggressive. 221565 FY, Mr. Johnson. Your charge was, I indicated, with 2 counts of in the 2nd degree, which is a felony punishable by up to 15 years imprisonment. You're also charged with assault with intent to, which is a felony punishable by up to 10 years imprisonment. As I mentioned, Prosecutor David Marvin is here. Deborah Davis is here from the prosecutor's office, and your lawyer, Tim George, who you refused to speak to. You told me several times that you have your own lawyer, who is your father or stepfather or somebody. What's the circumstance, Mr. Johnson? Mr. Johnson? I found you in contempt on October 24th. And that was 30 days, which is up November 24th. It isn't very effective for me to just find you in contempt every 30 days. I can't tell how much of this is a mental health issue, how much is just pure defiance or ignorance. Because we've never even had much in the way of engagement. You're extremely disrespectful to me by your behavior, but I'd like to move this case forward for your sake and the sake of the complaining witnesses. Let me ask you this. Do you have someone who is going to appear to represent you on your own behalf, on your behalf? Mr. Johnson. Well, we're not very successful. I'm going to order that he be examined for competency.
Again. Another one?
Well, what was the last?
He came back as competent.
Not in this case, though, in a previous
It's
case.
the case that we keep trying to have the competency hearing on. It was set for the competency hearing today,
The other case. For this case.
this case.
All right.
There is a report back,
Oh, that's right. That's
but we
right.
haven't been able to have the hearing because he's refused to appear for the hearing.
And the doctor is not available
The
today.
doctor's not available. We do have the doctor subpoenaed for the 15th, and
All
he is
right.
available on the 15th.
At what time?
I believe we set it for 1 PM.
That's wonderful. We have like 9 prelims all set at that same time, so this is gonna be very stressful. Mr. Johnson,
Can we confirm with Sergeant Hasbrook that Sergeant Hasbrook has been able to hear everything?
yes, obviously, Deborah, this, I don't need to comment. Can he hear us? Sergeant Hasbrook? Can you hear us? Can he hear us? All right. This is set for a pre-exam conference and the competency hearing. You went to the forensic center, were examined for competency. The doctor issued a report finding essentially you're competent, you're just uncooperative. But because you're so uncooperative, we can't stipulate to the report. So we're going to continue for a competency hearing. It was supposed to be this morning, but the doctor, we learned, was unavailable. Tim, this will be by Zoom. There's no need for you to come over here. We're going to have the doctor by Zoom.
I have other prelims, Your Honor, so I'll be here.
All right. For November 15th, 2022 at 1 PM for Zoom competency hearing.
As far as the preliminary exam, then, Your Honor, should we have our witness for that? Okay.
No, I assume this is going to be a struggle. If we find him to be competent, that's not a foregone conclusion, and I don't want to have you bring all those witnesses in.
Okay.
Can I still have a motion to be heard?
Yes,
In this matter.
Mr. George has a motion to withdraw.
All right, we will then plan for 1 PM just for the competency hearing portion of the case, and then I guess we'll go from there.
And
as
Mr.
far as
George's motion.
what we do.
Mr. Johnson? All right, we're gonna have a hearing next week. And if you're not cooperative, I'm gonna have you strapped into the restraint chair and brought into that room where you can hear what's going on. You're charged with very serious crimes, and you're not going to avoid them by just putting your hands over your ears and over your eyes and over your mouth. These matters are going to be addressed. So we'll be here next Tuesday at 1 o'clock with a host of other things. And we're going to address this. And you can think about it all week, but I'm going to buy an extra roll of duct tape and have them tape you in that chair and bring you in there where you and I can see eye to eye. But this only is going to work for so long where you pretend you're not involved and you are.
Your Honor, I actually just got a note from our staff that the doctor is scheduled for 8:30 with us next week, so if that helps the situation as far as scheduling.
All right, well, that'll be in the middle of pre-exams, but we'll set it for 8:30
Okay, thank you.
on November 15th. Mr. Johnson, I will see you at that time. Mr. George, I'm sorry you got stuck here. You won't be here at 8:30, so
I will
you
be,
can,
no.
all right. All right, well, he's still serving his contempt sentence until November 24th.
Thank you, Your Honor.
Thank you, Your Honor.
That was not very successful. All right, we are back. We're going to attempt this hearing on Mr. Chadwick Johnson, the Center for Forensic Psychiatry, Dr. Mr. Sheff is here. And we're attempting to have the defendant live streamed in from jail. This is not an encouraging sign. I'm going to go ahead and start the record. This is file number 221565, People versus Brad Lee Johnson. Mr. Johnson is charged with 2 counts of second degree and a count of assault with intent. He is presently in custody in the St. Joseph County Jail in lieu of a $100,000 bond. He is also serving a contempt sentence that I ordered 30 days of contempt for his failing to cooperate and appear. That was on November 8th. Mr. Tim George is here for the defendant, at least at this point, and Deborah Davis is here for the prosecuting attorney's office. Mr. Johnson has been essentially uncooperative, mostly passive aggressively uncooperative since the outset. He's continually said, Tim George is not my lawyer. Mr. George has filed a motion to withdraw. We had a competency order and a competency evaluation, which has been performed by Dr. Andrew Sheff. Because the defendant is so uncooperative, Mr. George is unable to stipulate to the admissibility of the report. And we're required to present testimony from the Forensic Center regarding the defendant's competence. And we're about to do that now. Once we do that, we will address Mr. George's motion to withdraw. Good morning, Mr. Johnson. Can you hear me? This is Judge Middleton. He nodded his head. He is in one of the conference rooms at the Sheriff's Department. He can't hear us. We're calling the matter. This is a competency hearing in the matter of People versus Brad Lee Johnson. File number is 221565FY. As indicated earlier, he's charged with 2 counts of criminal in the second degree and the count of assault with intent to commit. That allegedly occurred in July of 2022. Mr. Johnson was arrested on that matter, and he was ordered to be evaluated by the Center for Forensic Psychiatry. That has been done, and we have received a report from our doctor who is present. And we have had an opportunity to review the report. The doctor is Andrew P. Cheff, CHEFF, PsyD, a licensed psychologist and consulting forensic examiner from the Forensic Center. Mr. Cheff, can you hear me?
I can, Your Honor.
Laura, this is time for you to be here for the record. Mr. Cheff, would you please raise your right hand? Dr. Cheff, you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
I do.
So would you state your name for the record, please?
Yes, Dr. Andrew Sheff. Last name is CHEFF.
Deborah Davis is here from the prosecuting attorney's office representing the defendant, Mr. Johnson. Also present is representing the state, and Mr. George, Timothy George, is here presently representing the defendant. Mr. Johnson is on the screen there. You can see him. He is in sight and sound. He can hear us. Ms. Davis.
Thank you, Your Honor. Dr. Sheff, where are you employed?
The Center for Forensic Psychiatry with the Michigan Department of Health and Human Services.
And what is it that you do there?
I'm a forensic psychologist. My job duties are primarily related to evaluating defendants with regard to competency to stand trial and criminal responsibility matters.
Can you give us a brief overview of your education, your curriculum vitae?
Sure. I have a master's degree in clinical psychology, as well as a doctoral degree in clinical psychology, both received from the Illinois School of Professional Psychology in Chicago. I completed my doctoral degree in 2016. As part of my doctoral training, I completed a doctoral internship at the Federal Correctional Complex in Butner, North Carolina, which is a federal prison, where I completed forensic work as well as general clinical work there. After that, I started working for the Forensic Center in January of 2017 and completed the Consulting Forensic Examiner certification program there.
And do you have any continuing education that you complete?
Yes, we're required to complete 30 hours of continuing education requirements every licensing cycle, which is 2 years. Some of that's broadly clinical, some of it's more specifically forensic.
Approximately how many forensic evaluations have you completed?
Well over 500.
Your Honor, I'd ask to have this witness admitted as an expert in the field of forensic psychology.
Mr. George?
No objection, Your Honor.
All right, certainly from his educational background and his professional experience, Dr. Sheff is an expert qualified to give an opinion regarding the competency of this particular defendant, Bradley Johnson. So I will qualify Dr. Sheff as an expert entitled to give an opinion within his field of expertise.
Thank you, Your Honor. Dr. Sheff, as part of your employment, did you do a forensic evaluation on a Bradley Johnson?
Yes, I did.
And was that completed for his case in St. Joseph County, Michigan?
Yes, it was.
Do you recognize the person that you did this interview with in the virtual courtroom here today?
I do.
And could you state what he's wearing or what he looks like for the record, please?
He's dressed in some jail garb and he's appearing on a screen labeled St. Joseph County on my screen.
Your Honor, may the record reflect he's identified the defendant?
It may.
Thank you. Dr. Sheff, what can you tell us about the evaluation that you completed for Mr. Johnson?
For Mr. Johnson, I completed an interview with him over video conferencing technology, Zoom technology like we're using today. He was at the St. Joseph County Jail at the time. Lasted approximately an hour. It was on September 26th of this year. And I reviewed additionally some discovery documents provided, including a police report and complaint for the alleged offenses.
And throughout that interview, were you able to have a good connection through the video so that you could have an accurate conversation with Mr. Johnson?
Yes, the video and audio worked effectively.
And as part of your interview, was he compliant with you? Did he participate with you?
He participated in the interview. He was generally compliant, yes.
And what were your findings from that interview?
I opined that he was competent to stand trial.
So what is that based upon?
That's based upon my interview and discussion with him, the review of those documents I mentioned earlier. During the interview, he was aware of the allegations against him, the charges. He understood how court proceedings worked. He understood the utility of working with a defense attorney and appreciated those things.
Did you author a written report after this assessment?
I did.
And that written report, do you remember how many pages it was?
Approximately 7, I would guess.
And was it the report that was signed on 10/14 of 2022?
That's correct.
Your Honor, I move for admission of the report dated October 14th, 2022 as the exhibit A.
Does the report express the examination you did and the reasons for the conclusion that you came to?
It does, Your Honor.
And also expresses your opinion there in the last paragraph
That's correct.
that the defendant is competent?
Yes, Your Honor.
Mr. George, do you have any questions?
I don't have any objection, Your Honor.
All right, the report may be admitted. We've all read the report more than once. It does express the opinion that the defendant is competent, and I will accept the report.
I have no further questions for this witness. Your Honor.
Mr. George?
Thank you, Your Honor. Dr. Chef, you had indicated that you went through a training specific to doing these types of evaluations. Is that correct?
That's correct.
What type of, can you just describe what that training is?
It's a fairly long training at the Forensic Center. It entails attending some lectures, completing evaluations. I'm sorry, first observing evaluations that certified and consulting forensic examiners are completing of defendants, both for competence and criminal responsibility. Then completing evaluations under supervision of folks who've already achieved such certifications at the Forensic Center, and exposure to readings and things of that nature.
Do you know approximately how many evaluations you had to do under the supervision of?
Your Honor, I'm sorry to interrupt. I just noticed Mr. Johnson is no longer present.
He's in the room, I believe. Mr. Johnson didn't leave. We'll get him back on camera in a minute.
Or I just wanted to be sure that he didn't step out of the room or something like that.
He didn't. He stepped out of frame.
He's
Okay,
in the room. He can hear us.
thank you.
Dr. Chef, do you know approximately how many evaluations you completed under the supervision of an accredited evaluator?
At the Forensic Center, approximately 10.
And what types of things through your training are you looking for when you're doing an evaluation?
Understanding and capacity. So understanding the legal process and terminology and things of that nature and how it applies to an individual's specific case or circumstances.
So awareness of the court process, is that fair?
That's a portion, yes. Additionally, I would add reasoning abilities and capacity to work cooperatively with someone.
So that is looking more towards the ability for that individual to assist in his own defense. Is that correct?
That is correct, yes.
And now you had mentioned a couple of times criminal responsibility. That's a whole separate category. And that wasn't part of this evaluation. Is that correct?
That's correct. I only evaluated this defendant with regard to competency to stand trial.
Okay, so it's just that initial determination to see whether, like you said, he has enough awareness of the court proceedings and has the ability to assist in his own defense. That's really generally what that's limited to in competency evaluation. Is that correct?
That's correct.
Okay, and it's your opinion, based on your interview with Mr. Johnson, that he is able to assist in his own defense?
That's correct.
And he has an awareness of the court proceedings, the roles of different people within the criminal justice system, enough to be competent, in your opinion?
That is correct, yes.
Okay. I don't have anything further, Your Honor. Thank you.
Based on the testimony, Mr. Johnson, can you hear me? He's there. Thank you. And the report, I find that Brad Lee Johnson is competent. Mr. George did a good job in his examination at capsuling things, that he understands the nature of the proceedings against him and is able to assist in his defense. Mr. Johnson, criminal responsibility is a different issue. Sometimes it was called insanity, but that's your state of mind at the time of the offense. This offense is alleged to have occurred in the summer of 2022. This hearing has to do with your state of mind today. Are you able to understand the nature of the proceedings against you and assist in your defense? I've met you in the past. You're not cognitively challenged. You're an intelligent man. It's not a matter of the fact that you don't understand or not able to understand. And in the doctor's opinion, you are competent. And I find that you are, in fact, competent to proceed to the next stage of the proceedings. And I'm going to sign an order to that effect. Does anyone have any additional questions for Dr. Chuck?
No, Your Honor.
No, Your Honor.
Doctor, thank you for your time. It's very
You're welcome, Your
helpful.
Honor.
We've got other things to do to proceed here, but we will endeavor to do that now. Thank you. Mr. Johnson, we're not done yet. Please have a seat. Mr. Cheff, you're good to go.
Thank you, Your Honor.
Mr. Johnson, we got some other stuff to deal with. You had told me on several occasions that you did not want Tim George as your lawyer. Mr. George has been appointed by the court to represent you in this matter. And because of the very tenuous, in fact, worse than tenuous relationship between you and your lawyer, Mr. George has made a motion to withdraw as your attorney. The concern that I have is I don't know that you're going to get along any better with any other attorney that is appointed by the court. So would you have a seat for a moment so you and I could talk? Mr. Johnson, I'm trying to move this case forward for your benefit as much as everybody else's. I can keep finding you in contempt every time we meet and kick the can down the road, but I'd really like to get this matter joined and proceed to the next stage of the proceedings. So please have a seat so you and I can talk. All right, thank you. Mr. George has made a motion to withdraw as your lawyer. What's your opinion regarding that?
George is not my attorney. He's not a defense attorney.
I'm sorry?
Your license to be submitted into evidence, please.
The sound is really terrible.
I think he's gonna speak directly in the microphone.
Yeah. Thank you. Say that again.
I said, Mr. George is not my attorney. And I would
All
like
right.
to
Do you
request
have
that your
someone you're
license be
gonna have
submitted
as
into
your attorney?
evidence.
Do you have someone that you will have as your attorney? Mr. Johnson, what is scheduled next will be called a preliminary examination, where the prosecution must present evidence to show that there's probable cause to believe that a crime was committed and probable cause that you did it. That's called a preliminary examination. You saw Mr. George at work this morning. He's very competent and capable. He understood this proceeding. He asked relevant, meaningful questions. And he is a competent lawyer that practices here in our court all the time. You're charged with a very serious set of criminal offenses, punishable by up to 15 years in prison and up to 10 years in prison. Because of that, I strongly believe you need some legal representation to assist you in this process. When push comes to shove, you do have an absolute right to represent yourself. But the old adage is, it's a fool that has himself as his own attorney. You've continually told me that Mr. George is not your lawyer, but you haven't told me who is. Do you have someone that you wish to have represent you in this matter?
To be put into evidence, sir.
Say that again.
I would request your license put into evidence.
My license, Michigan State State Bar number P33555.
The bar is not a licensing authority.
Yes. I don't speak Sanskrit, but that's as relevant as what you're saying. The target is the fact that you're charged with some very serious felony offenses. You're shooting off in the woods somewhere with stuff that really isn't relevant. I am licensed as an attorney in the state of Michigan. I've been duly elected 8 times here in St. Joseph County. And I have the privilege of sitting on this bench. And I'm an employee of the Michigan Supreme Court. So you're stuck with me and I'm stuck with you. I just want to try to get to the next stage of the proceedings. The proceeding would be a preliminary examination where ostensibly this witness or several witnesses will be called to testify against you. And that would be set theoretically for next Tuesday at 1 o'clock. What's your position regarding that? Do you wish to represent yourself? All right. It's the doctor's opinion that the defendant is competent. He may be defiant, petulant, uncooperative, immature, any other number of things, but he is competent. And the fact that he's mostly unresponsive to everything doesn't mean he doesn't understand the nature of the proceedings. And being uncooperative, unresponsive is not going to make the case go away. My concern is that if I release Mr. George, he, the defendant, isn't going to be any more cooperative with any other attorney. He had at one point mentioned that someone was going to come in to represent him, but we've never heard from anyone else. Mr. Johnson, do you want a lawyer to assist you with this? All right. Well, he's competent. We can proceed to the next stage of the proceedings. Is next Tuesday the appropriate date, Ms. Davis?
That's fine, Your Honor. We can certainly get subpoenas out and have the victim here.
The defendant has left the room. And we're going to set the prelim for November 22nd at 1 o'clock. He can sit there and be sullen and petulant, but you're entitled to present testimony. Mr. George, I apologize, but I'm not going to release you from this case. You need some representation, at least through the preliminary examination. If there is probable cause, it'll be bound over to the circuit court. I do understand that you're in a very difficult position with a defendant that's as uncooperative as this. I will try to protect your ethical interests as much as Ms. Hines would like to handle this case. Anyone that's behind you would be stuck with the same set of problems that you are. So I'm going to, at least for the time being, deny your motion to withdraw. We're going to set the matter for preliminary examination, which will involve the testimony of a young boy. And probably not something I would live stream, but that will be set for next Tuesday at 1 o'clock. I will consider your motion to withdraw as a continuing motion, but at this time it's denied. And we'll set the matter for preliminary examination next Tuesday at 1 o'clock.
Thank you, Your Honor.